Hello, everyone. Welcome to Court with Krissy. Something you don't see in court very often. Not the mother withholding the children from the father part. It's the attorney decked out in camo. Kind of wild. I hope you like it. Court with Krissy is now in session.
All right, so Mr. Dobson is present together with his attorney by reliable electronic means with the court's permission. Attorney Byers is also present by reliable electronic means. Mr. Byers, you represent Ms. Johnson, at least co-represent Ms. Johnson, correct?
That's correct, Your Honor. I'm in a conference room in Grand Forks at the Indigent Defense Conference. I found out about this case yesterday and that somebody needed to step in for hear a copy, and so I did have my office staff file a notice of appearance, but I've only just gotten involved in this case yesterday.
And Mr. Byers, is your client also present?
He should be on the Zoom, appearing from the Larson Latham Huddle office in Bismarck. That was the plan. I'm not there to verify it, but I think the plan was to have, and I did talk to her by telephone about a half hour ago, and she wasn't.
I'm right here.
Okay, there we go.
Yep.
All right, Ms. Johnson is also present, again by reliable electronic means with the court's permission. Procedurally, this case is more complicated than it needs to be. A summons and complaint were filed with the court back on February 19, 2026. There was a service document filed on about that same date. The court entered a schedule for mediation, record index 7. There was an answer and counterclaim filed on March 5, 2026. That's record index 12. A reply to the answer and counterclaim was filed on the record index 15 on March 24, 2026. A motion and notice of motion for interim relief were filed and served on April 16, 2026. That's record index 19 is the motion. The notice of hearing is record index 18. A brief was filed in support, record index 20. A declaration of Mr. Dobson in support of the motion for interim relief was filed, record index 21, together with exhibits 1, 2, 3, and 4. That's record index 22 through 25 inclusive. Mr. Dobson filed the financial statement and declaration as required by North Dakota Rule of Court 8.2, record index 26. There was a service document filed, record index 27. And then a few days later, it looks like exhibits 5, 6, and 7, that's record index 28, 29, and 30, were filed with the court. Thereafter, there was a request to continue the hearing and extend the deadline to file an answer brief, record index 36, filed on May 7, 2026. There was a response to that request to continue, disagreeing with the continuance, objecting to a continuance because Rule 8.2 requires the court to hold a hearing within 30 days of the notice of motion and motion for interim relief. Although that request or that response did agree to a 5-day continuance to prepare responsive pleadings. Those pleadings, after the court signed the order denying the continuance, those pleadings were due on or before May 12 at 2 p.m. On May 12, a number of responsive pleadings were filed. There was an answer brief, record index 48. The answer brief reads more like a declaration. It's not signed by Ms. Johnson. Instead, it's signed by Gregory Larson on behalf of Mr. Copy. There were a number of exhibits that were attached to that answer brief, record index 50, 51, 52, 53, 54, 55. There is an unsworn declaration of service, record index 56, indicating that those documents were served on Ms. Brazel and filed with the court on May 12, 2026. The declaration of service does not make clear whether or not those documents were filed in advance of the 2 p.m. deadline or after the 2 p.m. deadline. The next day, I should have also mentioned that Ms. Johnson's financial statement is required by Rule 8.2 was also filed, record index 49. That financial statement appears to have been signed by Ms. Johnson. It says dated the 6th day of April 2026, but it appears to have been subscribed and sworn on May 6th. So I assume that that document was meant to have been signed on May 6th, and that's just a typographical error or a scrivener's error. Nevertheless, it was served on the 12th. One day later, on May 13, 2026, Ms. Johnson filed a declaration, record index 66. This declaration is, by not only the rule, but also the court's order, untimely. And it appears to cross-reference the exhibits which were filed attached to the answer brief filed by defense counsel. Ms. Brazel filed an objection, a general objection, saying that all of the documents, whether it was the answer brief, the exhibits, or Ms. Johnson's declaration, that all of them were filed untimely after the 2 p.m. deadline on May 12, 2026. There was other objections that the answer brief that may or may not have been filed before the deadline, that the answer brief filed by counsel is not a declaration subject to cross-examination and assumes facts not in evidence. Ms. Brazel asked the court to strike all of those pleadings as untimely. She also asks for 2 hours of attorney's fees in the amount of $800 for responding to declarations and evidence filed essentially on an emergency basis less than 24 hours before the scheduled hearing. We'll hear first from Ms. Brazel on her objections, then we'll hear from Mr. Byers. We'll deal with the objections, and then we'll get into the meat and potatoes of the interim motion hearing. Ms. Brazel.
Yes, Your Honor, thank you. As we've outlined in our objection, we believe all the filings are untimely. The rules are very clear that Ms. Johnson's response if raising new issues was due on April 30th, 2026. And if not raising new issues, her response was due on May 7th, 2026. And it wasn't until May 7th, 2026 that counsel for Michaela submitted that request to continue hearing and extend deadline to file answer brief. And in our responses in our proposed order, we wanted a denial of the continuation of today's hearing, but we did agree to a continuation of the deadline of responsive pleadings to 2 p.m. on Tuesday, May 12, 2026, and the court ordered that. But it wasn't until 3:52 p.m. on Tuesday, May 12th, that I was served with defendant's answer brief to plaintiff's motion, reference 48, defendant's financial statement and affidavit, reference 49, and defendant's exhibits A through G, reference 50 to 55. So these
Ms. Brazel, I'm going to stop you right there, and I'm going to ask a question, okay? So what the record reflects, or what I have in Odyssey, doesn't tell me whether or not those documents were filed before or after the 2 p.m. deadline. What evidence do I have that they are filed late, other than your statement that they were filed at 3:58? What proof do I have that is in the form of a declaration or some other form of evidence they were filed late?
I guess, Your Honor, I wasn't aware that the court doesn't have access to when these documents get filed. We receive a notification, so we have that documentation in our records, and I could certainly submit that to the court here within an hour's time, showing my staff could provide that to the court, showing when we received these documents. I just was not aware that the court could not view when the timestamp on the documents, but we have the timestamp that we can provide to the court.
Okay, so on my end, and what the Supreme Court would ever review is what you can see when you type in your attorney access for Odyssey, not the file and serve system, but if you would go to the Supreme Court's website, that's all they're going to see, is that they won't get access to the time date stamp. I could find it, but that's digging around in matters that aren't public and they're not made part of the record. They wouldn't be transmitted to the Supreme Court, but for some declaration saying, here's the time date stamp, judge, signed and sworn, Ms. Brazel. So I don't have access to that, or at least I shouldn't have access to that, because I would be doing independent investigation. That's really the attorney's job, to get me that information and make it part of the record.
I understand that, Your Honor, and I certainly can do that within the hour.
All right. So I interrupted you and sidetracked you. I apologize. Continue.
So we objected to that answer brief because it was not, we did not receive it by the 2 p.m. deadline. And then we objected to the contents of it because it's the answer brief, reference 48, assumes facts not in evidence, and it appears to try to put in statements of what the defendant should be making, because there's no way that counsel would have independent firsthand knowledge of the allegations that were stated in the brief, and then counsel put in exhibits without any proper foundation, and those exhibits also contain hearsay. And in addition, we are also objecting to the declaration that we just received yesterday at approximately 4 p.m. in our office, the declaration is untimely under Rule 8.2 D2, but it's also untimely under the court's order where the submissions were supposed to be to the court and to my office by 2 p.m. on Tuesday, May 12th. So I think it is clear, at least the record should be clear, that this was an untimely declaration, and we are asking that that untimely declaration be stricken from the record. If the court does consider it, then that's where we were asking for the additional attorney's fees to have to scramble to try to review and for me to review and confer with my client on that declaration. But we believe the appropriate sanction would be under the rules and under the court's order that declaration be Ms. Johnson's declaration be stricken from the record.
Ms. Brazel, this comes up occasionally in these interim motion hearings. If I strike Ms. Johnson's declaration, is that doing substantial justice to the best interest factors that I'm required to consider if I don't have, at a minimum, declarations from both parties addressing those best interest factors?
I think it still does substantial justice to the rules that are there for a reason, Your Honor.
All right. So, Mr. Byers, first, with respect to the objection to the answer brief containing facts not in evidence, what argument do you have with respect to that issue?
That it assumes facts not in evidence and that the exhibits contain hearsay are, I think I see those in divorce pleadings all the time. And so assuming facts not in evidence, there hasn't been a hearing by which the evidence would have been provided yet. So they make assumptions like that all the time, parties' allegations.
For these types of proceedings, the court is required to consider evidence by way of declaration, and you would agree that the attorney's brief generally relies on facts asserted by others. So in essence, it's a hearsay type argument, the entire brief. Would you agree, unless there's a declaration stating otherwise?
I agree, and it looks like that. I don't have any way to contest the fact that the declaration was filed afterwards, and I don't dispute any of what Ms. Brazel said about the untimeliness of any of those documents. But the situation we have here is Michaela Johnson is going to be held responsible or suffer the consequence of what looks to be Attorney Eric Copy's failings, and that's not right either. It appears to be the one responsible for the lateness of all of this. I don't have any indication that Michaela Johnson was the one to blame for things not getting filed when they should. We now have a doctor that has sent us a letter, I think that was probably filed with the motion for continuance, indicating that Mr. Copy needs a medical leave of absence for a period of at least 4 weeks. And so, yes, there's been failings on the part of the defendant in this case, but it wasn't Michaela Johnson's fault, and she shouldn't be suffering a consequence for that. If the court feels the need to sanction Attorney Copy, I can see that, but I really think it's unfair to Michaela Johnson to have an attorney attempt to conduct this interim proceeding with 1 day's notice on a cell phone when I can't even look at all the documents that were provided to me because all I have is that cell phone. What I would like to suggest to the court is that the plaintiff in this case get weekend visitation this weekend. We have as I understand it, a mediation scheduled for either the 26th or the 28th. If that mediation is not able to resolve a reasonable parenting schedule going forward during the interim, that we then have a hearing by which Michaela Johnson can be represented by appropriately prepared counsel, which I am not at this point.
All right, here's what I'm going to do. In terms of the attorney's brief is entirely based on hearsay and information for which the attorney would not have firsthand knowledge. I'll consider it argument. I do not consider it evidence. It does not meet the declaration requirements under Rule 8.2, which is the way the court is to receive evidence. The objection is sustained. In terms of the exhibits, there was a request to strike any untimely pleadings. Those exhibits were attached to the brief without foundation. The court sustains that objection. The exhibits are stricken. And what that means is I will not consider them as evidence in the evidentiary record. They will remain part of the case file in case ultimately this matter is reviewed by the Supreme Court. So those documents will have a clerk's entry behind each of the exhibits. And to be clear for the record, what I'm talking about, Exhibit A, Record Index 50, B, Record Index 51, C, Record Index 52, D, Record Index 53, E, Record Index 54, and G, Record Index 55. Those will receive parenthetical notation from the clerks after them saying not received. And again, I will not consider those exhibits as evidence. Those pleadings are not evidence. Again, the answer brief, the court sustained the objection as well. That will also not be considered as evidence. The court will consider it as argument. In terms of the defendant's financial statement, that record index 49, it appears to have been dated May 6, which is before the timeline. It was filed questionably late, and I don't have proof of that, and Ms. Brazel is going to file proof that it was filed late. Nevertheless, it's something the rule requires me to consider, so I will consider record index 49 and take it for what it's worth, give it the appropriate weight. With respect to Ms. Johnson's declaration, I struggle in striking that pleading as untimely because it is unquestionably untimely under the rule. It is unquestionably untimely under the court's very explicit order. But nevertheless, it is a party's statement. It addresses information the court is required to consider to make a parenting time and residential responsibility decision under case law and statute. I understand that the rule requires statements to be made by declaration or evidence to be presented by way of declaration. Here, unquestionably, this is late. I am going to allow that document to be received as evidence, but I am going to grant Ms. Brazel's request for attorney's fees in light of its untimeliness and its direct contravention of the court's order, granting an extension of time to respond. But I think it's fair and equitable as a remedy for that intentional disregard of the court's order to award attorney's fees concerning the emergent nature of the filing. Ms. Brazel has requested a total of 2 hours of prep time at $400 an hour. The court finds both the rate and the amount reasonable. Attorney's fees will be entered in the amount of $800 in favor of Mr. Dobson. The court, before going on the record, also considered the declaration of Mr. Dobson, record index 21, exhibits 1, 2, 3, 4, 5, 6, and 7 in the financial statement. So that's essentially record index 21 through 30 inclusive. Mr. Dobson is present. Court takes notice of those documents, and they will be made part of the evidentiary record. Ms. Brazel, I will require you as well to file a declaration or an affidavit addressing the timeliness of those filings. I just want it in the record. So if you could file that sometime in the next day or two, that would be fine. And I will also have you prepare an order on the court's objections or rulings on the objections. It can simply be for the reasons stated on the record. This is what happened. And with that being said, do you have any opening statement that you'd like to present before we get to the cross-examination phase?
Yes, Your Honor, just briefly, we just want to make it clear that, again, my client has not been allowed any contact, not even so much as a phone call, with both minor children since August 10th of 2025. So we are going on 9 months with no contact, no phone calls, nothing. And we think that's an egregious harm upon the children and upon Mr. Dobson's ability to spend time with the children and rights as a father. In the answer and counter claim that was filed March 5th, Ms. Johnson does admit that it's in the best interest of the children to have parenting time with Mr. Dobson. So it's very puzzling that here we are still 2 months after that filing, even where she still is not allowed so much as a phone call with the children. Now, all of a sudden, right before the hearing, we are getting documents that are alleging all sorts of forms of abuse with very scant foundation to that. I would say really no foundation, no credibility in these allegations. And what should be noted to the court is that there was a substantial period of time in April 2023 to January 2024 where Ms. Johnson left the children with Mr. Dobson in his primary care, and she moved to Bismarck. So there was 8 months there where the children were in his primary care. She returned to the home and then spent spent 2024 in Mr. Dobson's home with the children. And then in 2025, in August of 2025, she decides to leave the home and take the children with her. There's some references to incidents that happened between the two of them, but again, she has not presented any evidence to support allegations of domestic violence. And certainly there is nothing that she can indicate that there's any evidence of domestic violence that occurred between the parties within approximate time to the proceeding. And that's something that the court would need to consider. And it's also very sad that when Mr. Dobson tried to drop off presents to the children in December of 2025, that Ms. Johnson called the police and tried to make it out to be that he was somehow harassing or threatening her, which none of that happened. There was never a restraining order that resulted from this. And even though Mr. Dobson tried to see the minor children that day, tried to deliver presents, he was refused any contact with the children again. And then again, in February of this year, Ms. Johnson came to Mr. Dobson's home to retrieve more of her personal property. He allowed her to do that. He allowed her to even take beds for the children. And he, even though she'd already retrieved property back in August of 2025, he got a little bit of information about how the children were doing from her in that quick visit in February 2026. He allowed her to take whatever items she wanted for the children, but she did not bring the children with so he could see them. And there was no police report, no incidents reported from that. So it's very sad that instead of admitting that she just wants to control and cut off all contact with the minor children for Mr. Dobson, she's now making false allegations of abuse against him. It's not in the children's best interest to go 9 months without any contact with their father. He's submitted in his declaration and exhibits all the attempts he's made to try to contact the children. She then claims he's harassing her. I certainly don't see any harassment. There's been no evidence of harassment or stalking of any kind. And it's just very puzzling to us why this has taken 9 months now. Here we are today, and then they're wanting to continue it yet again. And then the counsel referring to any contact that Mr. Dobson would have as visitation is a very antiquated term. That would be parenting time. This isn't a zoo. We aren't visiting animals. This is about children. And it's very clear that throughout this declaration, Ms. Johnson is doing everything to malign Mr. Dobson's character rather than focusing what's on the best interest of the children. And in her untimely declaration, she still does not state what she believes would be in the best interest of the children for parenting time. So that's also very puzzling. It appears that she believes that no contact should be ordered as far as what she's stating in her declaration, whereas her attorney is saying that Mr. Dobson could have some visitation coming up on the weekends. We believe our proposed parenting plan is in the best interest of the children. The children are 10 and 5. They know Mr. Dobson, even though there's been a substantial period of time without contact, but it would be in their best interest to be able to have the summer with Mr. Dobson. And he has provided a proposed parenting plan. This would give him makeup time. He is on a layoff during the summer from his employer, where the building is very hot. They usually lay off employees from June, July, and then sometimes into August. So he would have a substantial amount of time to spend with the children where they wouldn't need to be in any form of summer daycare. And then Ms. Johnson could have every other weekend parenting time. We do believe that this schedule should continue into the school year so that the children can return. The oldest child for sure can return to the school that she's used to, and then the youngest child could enter kindergarten this year. We are lacking any information of where the children have been other than a potential address that Ms. Johnson was served at. We don't know where the oldest child, Nevaeh, is attending school. We don't know where the youngest child, Freya, is potentially attending daycare. She was set to start preschool in the fall of 2025 in Valley City, and that didn't happen. So we're lacking a lot of information about how the children are even doing. And as outlined in Mr. Dobson's declaration, we believe the best interest factor of Mr. Dobson and that the children should be returned to his care. And he was a primary caregiver up until Ms. Johnson leaving and absconding with the children and taking them to Bismarck without his permission. So we believe our parenting plan is appropriate and in the best interest of the children. And we did submit that as our Exhibit 1, Your Honor.
All right, thank you. Mr. Byers, any opening statement?
I would just reiterate that I think it's a disservice to my client to have to proceed forward with an attorney who just got notice of the case yesterday. And I know that's not the court's fault, it's not the plaintiff's fault, but it's certainly not Michaela Johnson's fault. I guess I'll just have to stand by the allegations that she makes in her declaration. That's the only document that the court's considering at this point. She does make allegations of physical abuse, emotional abuse, alleges that the father of the children is not an attentive parent, that he falls asleep a lot of times when he's caring for the kids, sometimes leaves the kids in the care and control of people who are not paying attention to them. I think she makes a case for the fact that the kids are in a place in Mandan where they're doing well. And so I don't think it's in the kids' best interest to necessarily uproot that, and certainly not in the children's best interest to be uprooted and have everything change without the court having a better handle on what all the evidence is that I'm not able to provide, having been asked to step in yesterday. That's all.
The court has already ruled on the request to continue.
Yeah.
If the filings were required to be filed before Mr. Copy's letter was even issued by his doctor, they weren't. Even after the letter was issued, there was a 7-day delay in notifying the court of the issue. The rule is quite clear that I am required to hold the hearing within 30 days of the motion being filed. The allegation is that there has been no contact with the children since August of 2025, and the children were substantially uprooted at that time. This matter is not about whether Mr. Copy is or isn't able to practice law. It's not about Mr. Dobson, and frankly, it's not about Ms. Johnson either. It's about the children. And so I am not going to continue the matter. I don't think the rules allow me to continue the matter. There's been an objection with respect to any continuance. The court granted an extension, which was stipulated to by Mr. Dobson. I understand Mr. Copy's concerns, and I am empathetic towards Mr. Copy's condition and situation. I am also empathetic and understand Mr. Byers' concerns. I have been put in that position as substitute counsel last minute too. I understand how difficult it is. That being said, the matter is going to proceed because it is in the best interest for the children for the court to proceed, and I think the rules require it. And so that was my decision before, and that's my decision now. So any request for continuance is denied. We're going to move forward today. Ms. Brazel, do you intend to cross-examine any witnesses?
Yes, Your Honor, I would intend to cross-examine Ms. Johnson on her declaration.
Ms. Johnson, please raise your right hand so I can see it. Ma'am, for the testimony you're about to give, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can lower your hand, and I want you to state and spell your full name for me.
Michaela Johnson, MAKAYLA JOHNSON.
And Ms. Johnson, the acoustics in my courtroom are not fantastic. So if you can be really loud and intentional with the way you're speaking, I would appreciate it. No one's going to be mad if you're yelling. It's so everyone can hear and the record is clear. So speak in your outside voice, if you would, please.
Yes, sir. My voice just might be shaky then.
I understand. So just speak as loudly as you can, and if I can't hear, I will ask you to speak up. Okay?
Okay.
Ms. Brazel, go ahead.
Please state your name for the record.
Michaela Johnson.
You submitted a financial statement and affidavit to this court. Do you recall that?
Yes.
Okay, and then this financial statement and affidavit, index number 49, is dated May 6, 2026. Do you recall?
I don't recall the specific date, but I do know it was before any of the deadlines for sure.
So you don't know if you signed it on April 6th or if you signed it on May 6th?
If it was in April, it would have been late April, but I'm pretty sure it was May. I just can't for sure tell you it was May 6th.
And according to this, affidavit, it appears you are unemployed at this time. Is that correct?
Yes, but I've been searching for jobs for the past 4 or 5 months.
Did you have a job upon moving to Bismarck?
No, I've been prioritizing my children's care and stabilization and stability.
Do you agree that you moved to Bismarck on August 10th, 2025?
No, I moved to Bismarck August 12th, 2025.
And since your move to Bismarck August 12th, 2025 to the present, you've been unemployed that entire time. Is that correct?
I have been volunteering and participating in programs that provide some money. Otherwise, I've had assistance with friends and family.
What employment have you had since your move to Bismarck to the present?
Employment, none. In volunteer work, I have had 2 different volunteer positions.
So you do not have a job where you are paid a wage. Is that correct?
Not currently. I have been searching. I do have evidence of that. I did submit that.
And you're saying that you receive child care assistance of $385 a month. Is that right?
I did, yes.
Are you still receiving that child care assistance?
Because of this court case and the issues with paternity and the refusal of paternity and state asking for paternity, it has been canceled.
Why were you receiving child care assistance if you were not employed?
Because I needed time to search for jobs and also time to do my volunteer work for TANF when I was receiving that.
Okay. And which child were both children receiving child care
No, Freya was in Shirley's Shining Stars. I did submit that to my lawyer. I was not aware of the deadline ahead of time because of the lack of communication, but I did submit that along with the record of Nevaeh's schooling.
All right, there's no question pending, so I need you to wait for the question and I need you to answer the question and just the question, okay?
Okay.
Go ahead,
Is Freya, sorry, Your Honor. Is Shirley Shining Stars a private daycare?
It is an at-home daycare. It is licensed through state.
And Freya was supposed to start Head Start in Valley City in August of 2025. Is that correct?
It is correct. I did attempt to apply her at Head Start here as well. It did not work out.
Okay, so Freya did not. Freya did have a spot available to her to attend Head Start in Valley City in the fall, correct?
I'm sorry, what was that?
Freya did have a spot available to attend preschool at Head Start in the fall of 2025 in Valley City.
Yes, I had registered her for that position.
Right, stop.
I did that paperwork.
You need
Yes.
to wait and not interrupt, okay? Wait for Ms. Razzle.
I was just trying to hear her. I'm
You're
sorry.
interrupting me, so stop. Just wait for her to finish her question before you start answering, okay?
Okay.
Ms. Razzle, please ask your question again.
Freya there was an open spot available for her to start Head Start in the fall of 2025 in Valley City, correct?
I believe so.
And when you moved to Bismarck, Freya did not Head Start program in Bismarck Mandan area. Is that correct?
Correct.
With Nevaeh was supposed to attend school in Valley City in the fall of 2025, where she had previously attended school. Is that correct?
Yes.
Then you moved in August of 2025 to Bismarck. Where did Nevaeh start school?
Roosevelt, where she's been since.
And is Roosevelt, let's back up here. When you moved, did you move to Bismarck or Mandan?
I was in Bismarck for a time living with my dad until I got an apartment a month later.
So you were in Bismarck living with your dad for a month. Is that correct?
Yes.
And then you got an apartment in what was that in Bismarck or Mandan?
Mandan.
Is Roosevelt in the Bismarck school district or the Mandan school district?
Mandan.
And Nevaeh had never attended school at Roosevelt previously. Is that correct?
Correct.
This apartment that you moved into a month after you moved to Bismarck, are you still living in the same apartment in Mandan?
Yes.
You moved to Mandan. Did you tell Brandon where you were living?
I was told no, because I was told by police not to tell him where my address
Objected,
was.
non-responsive, and hearsay, Your Honor. Move to
Sustained and sustained.
Okay, so you did not tell Brandon where your residence was when you
No.
moved to Mandan, correct?
Correct.
And you did not tell Brandon where Nevaeh was going to school, correct?
Correct.
You did not tell Brandon where Freya was going to daycare, correct?
Correct.
Since your move to Mandan, have the children, we'll start with Nevaeh, has she seen a pediatrician?
Yes.
How many times?
She had her wellness checkup.
For wellness check for what?
Her general wellness checkup once a year.
Was that for her 10-year birthday?
It was for what was needed. She hadn't seen the doctor in a while, so I had her go to the doctor. It was her 10-year wellness checkup.
Was this a new doctor that she'd never seen before?
No, she saw this doctor as a baby.
Did you tell Brandon about this appointment?
No.
What is Nevaeh's date of birth?
1/19/16.
Did you allow Brandon to celebrate Nevaeh's birthday with her this year in January 2026?
No,
With Freya, has she seen a pediatrician since your move to Mandan?
yes. Yes, she has.
Is that the same one as Nevaeh?
Yes.
How many times has Freya seen this pediatrician?
The same amount as Nevaeh once. She had her 4-year wellness checkup.
What is her date of birth?
12/24/21. She is 4, not 5.
Did you tell Brandon about this appointment?
No,
Did you allow Brandon to celebrate Freya's birthday with her in December of last year?
no,
When you first moved to Mandan, did you allow Brandon any phone calls with the children?
no,
Since your move to Mandan, have you allowed Brandon any phone calls with the children?
no,
Since your move to Mandan, have you allowed the children to spend any time with Brandon?
no,
In December, Brandon came to your residence to drop off presents for Christmas presents for the children, correct?
correct.
Did you allow the children to spend time with Brandon when he came to drop off the Christmas gifts in December of 2025?
No, we were all scared.
You're saying you were scared, is that correct?
No, my children were also scared. They were hiding in their room.
Were the children scared because you were acting scared?
No, the children were scared because there was nobody supposed to be knocking on our door.
Did you tell the children that it's their father and he'd like to see them?
No, because he shouldn't have been there. He wasn't invited. He wasn't supposed to have my address. I never gave that to him.
Did you, Brandon ended up leaving presents there, correct?
Yes, it was 2 blankets and 2 exact of the same stuffies. They're in a corner somewhere.
Did you give those presents to the children?
Yes, I did.
You called the police?
Because he told me he refused to leave.
Brandon was saying that he wanted to see the children, correct?
Yes, and I said that he was supposed to wait for my dad to respond because he had texted my father. He was supposed to drop off the Christmas presents with him. Before my dad had the chance to reply, he showed up at my doorstep and beat on the door, refused to leave until he saw the kids. I called my dad and he told me to call the police.
When the police arrived, it sounds like the police talked to both you and Brandon, correct?
I believe so. I don't know. I didn't open the door until the police came.
And Brandon left at some point after the police came, correct?
At some point, yeah, it did take a while.
You understand that Brandon wanted to see the children?
I understand.
And that Brandon hadn't seen the children at that point in 4 months.
I understand that. I'm not trying to get in the middle of their relationship with each other. I haven't contacted Brandon or given him my phone number because I don't feel like it's going to be productive. And that's why I did request to my lawyers a couple of times whether we could do a parenting app that is monitored. That I would be okay with for communication between him and the children. And that way it is monitored, nothing becomes out of pocket, everything is pertaining to the children.
Okay, but you understand that Brandon wanted to see the children in December, but you did not allow Brandon to see the children in December when he dropped off gifts, correct?
Because he did it inappropriately, yes.
But you think it was inappropriate for Brandon to bring gifts to your home for the children?
I believe it was inappropriate for Brandon to show up at my door when he should not have known my address.
You prior to this December, him coming to your home, you did not offer him any other way of seeing the children, correct?
Yes, but you could go about it in a different way. To have a family member stalk me and find my place of residence with my 2 children is incredibly scary
Objective,
and frightening.
Sustained.
Then in February of 2026, you came to Brandon's home to retrieve more of your personal property, is that correct?
Yes, I did send a letter. I did have the wrong address though.
And Brandon allowed you to come to his home and allowed you to get beds for the children, correct?
Yes.
And you told Brandon that the children had been sleeping on air mattresses up to that point, correct?
They were good air mattresses. Yes.
But you asked for Brandon's mattresses for the let me just rephrase that. You asked for the children's mattresses that were at Brandon's home.
Yes, I did pay for one of them though, correct?
And Brandon allowed you to take those mattresses, correct?
Yes.
The police weren't called during this personal property exchange, correct?
Everything remained civil. I did have a third party there as a mediary.
Everything remained civil in February 2026 when you went to get your personal property from Brandon, correct?
Because I had a third party, yes. Had it just been me, I don't know.
Who was the third party?
Chasquet Old Rock.
Sorry, can you say that name again?
Chasquet Old Rock.
And that is the person sitting with you in that conference room, is that correct?
Yes.
And is that person a friend of yours?
Yes.
Are you in a romantic relationship?
No.
And in your current residence, how many bedrooms are there?
2.
Do the children share a bedroom?
Yes, they have a bedroom to themselves.
Are you in the other bedroom?
Yes.
Does anyone else live with you?
No.
Are you in a romantic relationship with anyone?
No.
Do you currently have a driver's license?
I am in the process.
Do
I
you
have a
currently
permit.
have a valid driver's license?
No.
So how do you transport the children to school or and daycare?
Navia takes the bus. I walk Freya. It's not that far.
How do you get to other places such as a grocery store?
I have family and friends. I have lots of familial and friend support.
They drive you where you need to go.
If needed, yes.
So if Brandon is awarded any parenting time with the children, how are you going to be able to do any of the transporting for parenting time?
I can. I just need to know ahead of time.
And then you'll have a family member or friend help with transportation?
Yes, until I get my license. It is soon. I will.
Do you have a driver's permit?
Yes.
How old are you?
30.
When are you taking the driver's license exam?
Within the next couple months.
And you stated in your declaration from index number 66 that you and Brandon began dating in late 2025. Is that correct?
We began dating in 2025? No.
Okay. When did you and Brandon begin dating?
April of 2015.
Okay. And you're saying during the relationship together, Nevaeh was born in 2016 and Frey was born in 2021, correct?
Correct.
You indicate that Brandon was physically abusive towards you. Is
Yes.
that correct? What is the date when he was first physically abusive to you?
I don't know a physical or an actual date. I can tell you the first time he got physical with me and not just intimidation or threatening behavior was, I want to say, early 2022.
So you're saying the first time he got physical with you was in early 2022?
Yes.
You had said that he would damage property. What's the first instance of him damaging property?
Oh, he would bust random pieces of wood. He would burn things.
What's the first instance of him damaging what's the first instance of him damaging your property?
My property, personally,
Yes.
He smashed my phone on the edge of a bookcase to prevent me from recording.
Is that so? The first incident, is that what you're referring to as far as?
No, that's not the physical abuse.
So you're saying he smashed your phone one time?
He smashed my phone once. He's taken it away multiple times.
And you and Brandon had an on-again, off-again relationship for many of the years of your relationship. Would you agree?
Yes.
You referenced that Brandon had an airsoft gun. Do you agree that Brandon got rid of the airsoft gun when you asked him to get rid of it?
I don't know. He has a tendency of hoarding things I tell him to get rid of. So I don't know if he actually got rid of it.
And then as far as him having any other gun, he did not purchase any other handgun until 2023 after you broke up, correct?
Yes. While he was with my children.
And did Brandon tell you that he got a handgun for safety reasons?
No, he just said he got one because he wanted one. He wanted to go shooting.
Are you aware that Brandon kept it locked?
Not always.
Well, did he keep it up and locked and safe from the children?
Usually, yes. The gun, not the knives. Yes.
Well, I'm talking about the gun. Let's back up. Did Brandon?
The gun, yes. He had it in a box.
Stop.
It was not always.
Stop.
locked. I'm not trying to. I'm sorry.
I've let it go on a long time now. You have repeatedly interrupted Ms. Brazel. You need to wait for her to finish the question before you start answering. She will wait for you to finish your answer before she asks her next question. I don't want to say it again. Ms. Brazel, please ask your next question.
So Brandon kept the gun in a safe away from the children, correct?
Yes.
You're stating that Brandon would pull that firearm out during arguments? Is that correct?
Yes.
Is it the handgun that he purchased in 2023?
Yes.
How many times did he pull out a handgun during an argument?
He did it twice early on in 2024, I believe.
Did you call the police?
No.
Brandon hasn't been arrested for any charges related to firearms, correct?
Not that I know of, but I don't know his record, admittedly.
And you're indicating that Brandon you said he left knives around the residence and would pull knives out during arguments. Is that correct?
Correct.
Were there times that you and Brandon would be arguing and he would be cooking in the kitchen with knives?
No.
Did you call the police at any time when he would be using a knife during argument, as you say?
No.
You referenced an incident in October 2022 where you say Brandon physically assaulted you during an argument. Was this an argument where you were wanting to leave, but Brandon wanted you to keep the phone there because he paid for it?
No, that was not the incidents.
You indicate in your declaration that there was the phone got smashed. Is that correct?
Yes.
Did you call the police during this incident?
I might have. I don't know for sure.
Were there any charges that ever resulted from this incident?
No, it's always been domestic disputes.
Were there arguments? Did Brandon get upset with you because he would be working all day and he'd come home and he'd have to start cleaning the house?
No.
You never had arguments about Brandon being exhausted and you saying that you needed me time, so he needed to start cleaning the house and take care of the children?
We had arguments, but that was not the result of it, and that was not the start of it. That was part of the argument, yes.
So you agree that there were arguments between you and Brandon due to you staying at home and not cleaning the house, correct?
That's debatable.
Do you agree that Brandon provided the majority of the financial support for you and the children during your relationship?
Yes.
And you also referenced an April 13, 2023 incident where you said that there was a disagreement between the two of you and there was some damage to the door frame during that incident, correct?
Yes, Brandon had busted the door frame open.
And did you call the police during this incident?
No, the children were sleeping.
You ever gotten angry with Brandon?
Gotten angry, yes.
Have you ever called Brandon names?
Yes.
What sort of names would you call Brandon?
I call him dumb.
Anything else?
Whatever he had called himself.
Well, what other names would you call him?
I honestly can't remember. It's been months and it had been years and years of a relationship. I don't remember.
Were you at times mean to Brandon?
I was mean back, yes.
Did you ever hit Brandon?
Not unless it was self-defense.
Did you ever hit Brandon?
Not unless it was self-defense.
So that means are you saying that you did hit Brandon?
I'm saying I defended myself if I needed to.
Did you hit him in the face?
No,
Did you hit him in the body?
no,
Did you push him?
no. I would try to get out of the doorway. He would block the doorway.
Did you ever assault him in any way?
I don't think so.
Did you ever throw anything at him?
No.
All right. In April of 2023, you say that you packed your belongings and it sounds like you moved out of the residence you shared with Brandon and the children. Is that correct?
To be completely honest about that situation, he had started packing my belongings for me and then told me I had to leave. So I felt like I had no choice.
Did you move out of the?
I did move out because I felt like my safety was threatened, yes.
And you left the children with Brandon in April of 2023, correct?
Knowing that I would come back for them, yes.
Okay. And then you were moved out of the residence that you shared with Brandon and left the children with him from April of 2023 to January of 2024, correct?
I believe so. I think it was early February of 2024 that I moved back officially.
Okay, so and where were you living?
I was living on my own in Bismarck.
And during
I
that
got
time,
an apartment. Sorry, I'm sorry, I didn't mean to interrupt.
You got an apartment by yourself?
Yes.
Were you living with anyone else?
No.
Did you move for a job?
I moved for job opportunities.
Did you get a job?
I did.
How long? What job was that?
I worked as a cook at Edgewood Estates for
For how long?
$18.50 an hour.
Sorry, for
Sorry,
how
what?
long?
For how long? I believe it was about 6 months. 6 or 7.
And then during that time, the children resided with Brandon from April 2023 to February 2024, correct?
Correct. They would come down for visits.
Brandon would bring the children to you for visits, correct?
Twice I did go visit them, but yes.
Brandon would allow you phone calls with the children as well. Is that correct?
For the most part, not always.
You said Brandon would bring the children to you for visits.
Yes.
Okay. And would you say that you would have, during that time frame, did you have every other weekend parenting time?
No, not every other weekend. It's whenever it was convenient for him to bring them down. It was winter time, so it was kind of hard to travel.
And you're saying that you only went to see the children twice during that time?
I was only able to, yes.
Is that because you did not have a driver's license?
Driver's license, and I was busy with work.
During that time frame, did you ever make any reports to Child Protection Safety because you felt like the children weren't being cared for by Brandon?
No, but I should have.
Did you ever call the police because you were concerned about the children's welfare?
No, I felt like that would be traumatizing to them.
Then you returned to the residence in Brandon's residence in 2024 and stayed there for the next year and a half until approximately August of 2025. Is that right?
Yes.
The time you would leave the children alone with Brandon, correct?
I'm sorry, what?
During that time frame when you moved back in 2024 to when you moved out in August of 2025, you would leave the children alone with Brandon, correct?
Incorrect.
You're saying you never once left the children alone with Brandon in that year?
I'm not saying I never once did, but to say I always left them alone with him would be incorrect. He was with his mom for a majority of that, so he had help watching them. I'm just trying to remain completely honest.
Was Brandon ever alone with the children during that time frame?
Occasionally, yes.
And you complained that there was household conditions like excessive dishes, clutter, and bed bug issues. Is that correct?
Yes.
But you were living in the home and could also be cleaning, correct?
I was cleaning.
So despite cleaning that you were cleaning, you're saying there still was excessive dishes, clutter, and bed bug issues?
Because every time I would do dishes, there would still be more.
Well, that's partly your responsibility, isn't it?
It's partly my responsibility, but it felt like I was the only one trying to take care of the issues in the household.
Were you working during that time frame?
Some of it, yes.
Or where did you work?
I worked at Open Door overnights for about 6 or 7 months. During that time, I was still expected to take care of the kids and clean the house as well. So I was doing my share.
So there were times between 2024 to when you moved in August of 2025 that you were unemployed. Is that correct?
Yes, there was times that I didn't have a job.
Why did you move back from Bismarck to Valley City in February of 2024?
Because it was really difficult on the children to be apart from me, and it was hard on me too to be apart from my children, so I wanted to move closer to co-parent with them better. I thought that was a doable thing because I thought everything was cordial between us.
Were you still employed when you moved at
When
that
I
time?
moved, no.
So had you quit your job or been fired?
I had to quit because it was a very unhealthy environment.
And then when you returned, why did you live with Brandon instead of getting your own residence?
Because it was easier for childcare if I was there. At the time, Freya did not qualify for Head Start or anything, so.
So when is the last time that you've had a job where you were paid wages?
December 2024 or January 2025, I believe, where I was actually paid wages. I have found other ways to make money though.
Okay, so it's been approximately 18 months since you've been employed. Is that correct?
Yes.
Do you have any mental health issues?
None that are severe would interact or be an issue.
Do you have any mental health? Do you have any diagnoses like anxiety or depression?
I have anxiety and I have depression, yes.
Any other diagnoses?
PTSD.
Do you have an actual diagnosis from a medical provider of that?
Yes.
Are you on any medications?
No.
You don't take any medication for your anxiety, depression, or PTSD?
No, I have coping skills.
Or do you see a counselor for this anxiety, depression, and PTSD?
I will be going to a therapist here soon. I just got insurance, so.
What is it? Where do you have insurance through?
It's the Medicaid expansion.
What insurance do the children have?
Medicaid.
How are you currently paying your rent?
It was TANF before. Now it's a personal loans from friends.
Do you have any plans to move from your current residence?
My lease is up in October.
And are you going to move at that time?
If I can find a bigger place, yes.
Would you stay in Mandan?
I would prefer to. It's quieter.
Is Nevaeh in any extracurricular activities?
No, but she is working on how do I phrase this? I'm sorry. We're trying to find a extracurricular in the summer that she would enjoy. A lot of them are pretty physical. So she's looking into taekwondo and karate for the summer.
Since your move to Mandan, has Nevaeh been in any extracurricular activities?
Not yet, no.
With Freya, is she in any extracurricular activities?
Not yet, no.
Since your move to Mandan, has she been in any extracurricular activities?
No, not yet.
And then who are the family members that spend time with the children?
That would be my dad, my cousins, and my extensive list of aunties.
Were you in foster care because of your dad's abuse of you?
That wasn't because of it, but it was part of it, yes.
So part of the reason you were in foster care was because of your dad's abuse of you.
Yes, he's gone to therapy. He's nothing like he was before.
Do you allow your dad to watch the children while unsupervised while you're not there?
No,
Have you allowed anyone other than the daycare to watch the children while you were not present?
yes, my cousins, Allie and Mary. Allie works for YMCA as a daycare provider, so she is experienced and has CPR training.
Do you allow anyone else to watch the children when you were not present?
No,
When you took the children with you to the Bismarck-Mandan area in August of 2025, the children had stated that they wanted to stay with Brandon, correct?
they did briefly. They mostly just wanted to stay together. That was their biggest thing.
And the children wanted to stay in Valley City where they had friends and where Brandon was, correct?
They have changed their opinion on that, correct? But yes.
What I'm asking about initially prior to you
Yes,
moving,
they were
said
upset
wanted
about
to stay.
leaving Valley City.
So
I'm
again,
sorry, I didn't mean, I thought she was done speaking. I didn't see that her green box was going. I honestly didn't hear her. I'm sorry, please.
you need to
Ask
wait.
again.
Like, I'm really getting frustrated because this makes it very difficult for my court recorder to keep things straight. You need
I'm
to
sorry.
wait.
I'm sorry. I thought I saw the green box stop glowing. That was my bad. I apologize.
All right.
What have the children asked to see Brandon, their father?
They have not asked to, no. They have asked if he's okay.
What have you told them about why Brandon hasn't been able to see them?
I have tried my best to keep all of this between him and I, because it's not good for the kids to be exposed to too much of this. I did tell them that their dad and I do not get along well. That their dad does not always treat people the best. and that he needs some space. And that he loves them very much and that he misses them. And that I'm not trying to take them away from him, but we're trying to figure it out in the best way that we can.
Would you agree you did take the children away from him?
I agree, I have kept them away from him longer than I needed to, longer than I was meaning to. Longer than I meant to.
Did you agree you kept them away from him for 9 months?
I agree, yes. That was not my intention.
But that's exactly what happened, isn't it?
I'm aware. But as I said, it was not my intention.
What was your intention?
My intention was to try to get this resolved. I had been trying to find a lawyer for some months before all this. Brandon just happened to find you before I was able to obtain a lawyer. I wanted to get this all sorted out through the court system, and that way there was no shady business from either side of us. There was no trying to twist the kids on each other. There was none of that. I wanted it to be done as cordially as possible and as effectively as possible. I do apologize for it taking this long. It was not my intention. What I have always wanted was communication between him and I that is effective and based solely on the kids and kid focused, and to be able to communicate about them and their well-being.
But you have blocked him on your cell phone, correct?
Correct, because I am not confident that him and I can keep it solely about the children. Because
But why
before when we
can't you-
tried this in 2023, it did not work out well. That's how it went off the rails. So I was trying to avoid that happening again.
But Brandon did reach out to you and he submitted exhibits saying he misses the girls and he just asked you to at least have them call and talk to them.
I did not receive those texts. He had been blocked already before I received those.
And you didn't make any attempt. What about calling him on someone else's phone so that the children could talk to him? Why didn't you do that?
Because I didn't want to involve somebody else in what was going on between him and I. That was messy.
You could set up a FaceTime that wouldn't allow him to have your phone number, correct?
I don't have FaceTime. I don't know how to do that.
You don't have any way of any form of other electronic communication so that the children could have video chat with Brandon?
I have my cell phone. I could have downloaded a text now number, but it's not always reliable.
So you're saying there was other things you could have done. You agree that there's other things you could have done so that the children could have seen, at least had video contact with Brandon, correct?
Correct, but I also don't believe that it would have stayed cordial. And that's what I was trying to maintain. I wasn't trying to escalate whatever was happening between him and I by giving him access to contacting me.
And by not giving him access to contact you, you also cut off his access to contact the children, correct?
Correct, but that was not my main intention. That was not what I was intending at all.
You never contacted Brandon so he could even meet you and the children in a public place so he could see them, correct?
I don't feel safe doing that, really.
You're saying you don't still feel safe meeting Brandon in a public place with the children?
Not really, no.
Even though recently in February of 2026, there was a personal property exchange and nothing
because I
bad happened
had
between-
somebody I trusted there.
Okay,
Yes.
so you're saying you couldn't even bring somebody that you trusted with in a public place so Brandon could see the children in these past 9 months?
We would have had to organize that through a text of somehow. And that wasn't. I was told not to give him my address or my phone number by the police in Valley City, so I was just trying to maintain that.
I'm going to object as hearsay and move to strike as non-responsive.
Sustained, motion granted.
Do you think it's in the children's best interest to not have contact with Brandon for 9 months?
No.
I have no further questions.
Mr. Byers, the rule doesn't mention or discuss any redirect, but it is my common practice to allow a brief redirect that is limited directly to the scope of cross-examination. You can go ahead and ask questions if you wish.
Thank you. Michaela, the counsel for Brandon asked about abuse. And you started to talk about him smashing your phone, pulling out guns or knives during arguments. Was there an incident where you wound up with some kind of a fat lip or a cut in your mouth or something?
Yep. I can't remember if it was the exact time where the phone got smashed or if it was another argument, but there was a physical altercation where he had thrown me against the wall while I had Freya in my arms, and it ended up hitting me in the lip and cutting open the inside of my lip.
What wound up hitting your lip?
His arm or his fist or something. I don't know, it was all happening so fast.
And your insistence on not giving out your address and your telephone number, you're indicating that part of the reason you did that because the authorities told you to do that.
Yes.
Objection, hearsay.
Sustained.
Correct. Can I, for just one time, Your Honor, have a chance to respond to the objection?
What is your response, Mr. Byers?
That it's not for the truth of the matter asserted, but to explain why she did what she did.
So,
which makes it not hearsay if it's not for the truth of the matter asserted.
then what's its purpose?
To explain the witness's conduct, why it was that she kept her address and phone number secretive.
Ms. Brazel?
Your Honor, I think that still is hearsay because we don't have an officer here to testify as to whether or not that was even what was stated. So it lacks foundation as well.
I'll consider it for effect on listener. I'll overrule the objection. Go ahead, ask your next question.
Okay, thank you. Michaela, you had indicated that there were times when you were living there and you left the kids in the care of Brandon, and a lot of times it was with his mother present. Did you feel better about the situation if his mom was present?
I mean, if there was more of a chance that one of them would have woken up, because a lot of the time both of them were sleeping during the day when both kids were conscious. So yes, I did feel more confident when there was another adult there in the parenting abilities.
Okay. Can you just indicate to the court how the school has been going for Nevaeh?
On her last tests, she got all straight A's. She has improved since the fall. She was not testing low in the fall at all, but her test scores still have improved since the fall. The last parent-teacher conference I had with her teacher, Mr. Peterson, he indicated that she has been doing wonderfully in all of her classes, that she loves doing all of the reading assignments, and she's very
Objection.
passionate about science.
Hearsay.
Mr. Byers?
It's just for general background information, Your Honor. Do we really want to call teachers and principals and superintendents into these hearings?
Is there an exception under the rules of evidence?
I'd say it's just a public record. My question really related to how the kids are doing and not what the teachers say about it. I know that's where the answer started heading, but
Yeah, she's got straight A's.
So
She's
stop,
doing wonderful.
stop. So objection sustained. It's not a public record. Educational records are protected under both federal and state law. It's not a public record. It is offered for the truth of the matter asserted, not by the question asked by Mr. Byers, but the answer of Ms. Johnson. So the objection is sustained. Go ahead.
how has the kids' behavior been, Michaela, during the last 9 months or so?
They have been able to regulate their moods a lot easier, having a stable, consistent routine. They have been able to be open about their anxieties and worries with having an open communication and a nurturing environment.
I understand from your responses to plaintiff's questions that you do understand that Brandon has to have parenting time, and that may be in the best interest of the kids for him to have parenting time.
Yes.
Okay, I don't have any further questions, Your Honor.
Ms. Brazel, any follow-up?
No, Your Honor.
All right, thank you. And Ms. Brazel, there's no other witnesses that have filed declarations, so I'm assuming that means that you rest at this time?
Yes, Your Honor.
All right, Mr. Byers, do you intend to cross-examine Mr. Dobson?
I do not intend to ask him any questions in response to his declaration, Your Honor.
All right, and that was the only declaration filed on behalf of the plaintiff. And so I'm assuming, Mr. Byers, that means you rest?
Yes.
All right, any closing argument, Ms. Brazel?
Well, typically, Your Honor, there would be a cross-examination on my client's declaration, which would then allow me some redirect, which would have allowed me some opportunity to address some of Ms. Johnson's allegations. But my client, I believe Mr. Dobson, could explain a lot of these circumstances very well in his redirect, but I realize we're here on an interim, and this declaration that was untimely was allowed in and I understand the reasons. So what I can say, Your Honor, is that I believe my client's declaration still outlines very well why it is in the best interest of the children to be in his primary care. I think that Ms. Johnson's testimony about any prior alleged incidents between her and Mr. Dobson were very self-serving and lacked any evidentiary support. And if in any event, whatever she claims happened as far as any physical violence or emotional abuse, it does not fall under the best interest factors as far as domestic violence goes, because that would have to be where there was a serious bodily injury or a weapon used or a pattern of incidents with an approximate time to the proceeding. And according to her own declaration, the last incident that would have happened between the two of them hasn't been since 2022, or I apologize, 2023, when the police may have been called. So we don't have any incidents of domestic violence under the best interest factors that would have occurred with an approximate time to the proceeding. And the last incident, again, that she claims to have happened, we are not saying that anything happened according to what she is saying, but that last incident was April of 2023, and she left the children in Brandon's care for approximately 9 months, almost 10 months, from April of 2023 to February of 2024. So obviously she felt it was safe enough for the children to stay with Brandon during that time when she moved to Bismarck. During that time frame, her and Brandon were able to co-parent pretty well, and he brought the children to her, and she went and saw the children. He did not prevent the children from seeing her, and this was even after she had alleged so many incidents had occurred between the two of them. So it's very surprising that now here we are with 9 months of her not allowing any contact with Mr. Dobson. She agrees that it wasn't in the best interest of the children to allow him any contact. It's ridiculous that she wouldn't allow any form of electronic communication between the two of them. She wouldn't allow any form of contact between the two of them. She's got other family members in town that could have helped facilitate parenting time if she were truly afraid. And she even admits that in February, as recent as February, her and Brandon had an exchange of personal property, and there was no altercations between the two of them. So this was not in the best interest of the children for Brandon to have 9 months of no contact with them. That could cause severe emotional trauma to them and could cause potential long-term abandonment issues for them with not seeing their father. And it's very shocking that she just treats this as no big deal, and with a very cavalier attitude about the long-term impacts of the children and from not seeing their father for so long. So we again believe that the requests that we've made in the motion are appropriate, that the parenting plan that we've outlined is appropriate, and we ask that the court grant Mr. Dobson's proposed parenting plan as outlined in Exhibit 1, Your Honor.
Thank you. Mr. Myers.
Yes, Your Honor. I can't answer to all of what's taken place before I got involved in this, but what I see now is that it would not be in the best interest to make a drastic change in their living circumstances, the school for the one child. So what I'm asking the court to do is allow some weekend visitation until school is out, which could be this weekend, that Brandon get some extended parenting time during the summertime, and that as far as a permanent parenting time decision and schedule, that decision by this court wait until after the parties have had a chance to participate in mediation, which may work through some of the communication problems. So I'm just asking for a weekend visitation for Brandon for now till school's out, and then some extended parenting time, and that the parties communicate using a parenting app.
I'm sorry, I didn't quite hear your last statement, Mr. Byers. Communicate with
Because of the concerns about this maintaining on the subject of co-parenting, that the parties communicate with each other using a parenting app, which would alleviate my client's concerns about it going off track.
How does your client propose to pay for a parenting app?
Well, as it is now, she's indicated that she's getting by from loans from friends. And so I think it would have to be on that, unless, Michaela, unless you're able to offer the court any other source that you may have for paying for the parenting app.
Not at this time, no.
And Your Honor, on that, the best app typically is Our Family Wizard, and those charges vary, but they're usually around $144 a year, approximately $12 a month per person. And that's for a very basic plan. To have sometimes additional features that can be more expensive. I know my client doesn't have extra money to put towards a parenting app with all the attorney's fees he's expended. And it sounds like Ms. Johnson also doesn't have any extra funds to spend on a parenting app. And I just failed to see why there needs to be a parenting app in this case, because Ms. Johnson never put in any evidence of any harassing text messages. We don't have any. There's none. There's no nasty text messages between the two of them. So I don't understand why there would have to be an extra expense. I mean, this isn't a case where I've seen pages and pages of people, calling each other horrible names in text messages. She's presented zero evidence of that. So it just doesn't seem like it's even necessary.
Thank you. Mr. Byers, anything else in terms of closing argument?
No, Your Honor, thank you.
Ms. Brazel, any rebuttal?
I probably jumped the gun there a little bit, for lack of a better term, Your Honor. That was basically what I was going to just say, is I understand that sometimes they can be helpful in cases where there's been a lot of hostility between the parties, but I haven't, Ms. Johnson hasn't provided any evidence of that. And my client certainly hasn't indicated there has been any text messages between the two of them where anything has gone off the rails. So I still think text messaging and cell phone communication between the two of them is still the best option. I would certainly advise my client to be civil at all times. And while the parties are being monitored by the court and the attorneys, I don't think it's necessary to instill yet another an expense on them.
All right, thank you. The court in interim motion proceedings under Rule 8.2 concerning parenting rights and responsibilities and residential responsibility and parenting time is required to consider the children's best interest factors set forth in North Dakota Century Code Section 1409 6.2. With respect to the court's findings, the court is going to enter an interim order today orally, and then I will have one party prepare a proposed interim order that's consistent with the court's oral findings. And Ms. Brazel, because you are the attorney that asked for it, I'm going to ask you to prepare the document. With respect to the findings, I'll have you just simply say the best interest factor analysis was put forth on the record and it's incorporated in this order. But the terms of the actual interim order, I will have you include those in the proposed document as close as you can keep track. And where they deviate from your request, I will certainly identify that and make it clear what I intend to order. With respect to factor 1, the love, affection, and other emotional ties between the parents and the child, and the ability of each parent to provide the child with nurture, love, affection, and guidance. The court finds that both parents have the capacity and appear to love and have affection for and emotional ties with both NJ and FJ, the children at issue in this matter. The court finds that those ties and that love and affection existed and has existed throughout the entirety of the children's lives. The court has some concerns about both parents providing adequate nurture, love, affection, and guidance when it comes to some of the allegations made by Ms. Johnson concerning how Mr. Dobson parents, and Mr. Dobson's allegation about Ms. Johnson essentially absconding with the children and being willing to withhold and alienate him from the children's lives and be manipulative with the children. The court has concerns there to some degree with both parents, but ultimately I think this factor is neutral. I think both parties have love and affection and emotional ties with the children. I'm not going to hold the period of time that Mr. Dobson has been without the children against him in any way, saying that that somehow decreases his emotional ties with the children due to factors beyond his control. I think each parent has the ability to provide the children with nurture, love, affection, and guidance if given the appropriate opportunity to do so. Factor B, the ability of each parent to assure that the children receive adequate food, clothing, shelter, medical care, and safe environments. Here, Mr. Dobson has alleged that that factor weighs in favor of him because he was the financial provider throughout the children's lives, is able to provide adequate food, clothing, shelter, and medical care. He has medical insurance that he can put the children on. Mr. Dobson paints his environment as a safe environment. Court has no reason to find that that isn't true. In terms of Ms. Johnson's ability to provide adequate food, clothing, shelter, medical care, and a safe environment, the court does have some concerns about Ms. Johnson's ability to provide the children with adequate food, clothing, shelter based on her unemployment for a substantial period of time and her reliance and dependence on third parties to provide her with assistance, both in terms of finances, which are necessary to purchase food and clothing and provide shelter. The children appear to be on Medicaid and have seen a pediatrician once each. There's no reason to think that that's inappropriate, but it perhaps isn't the best care. It's probably not the most frequent of care. In terms of a safe environment, Mr. Dobson's declaration did set forth information concerning his environment. And the court again has no reason to disbelieve Mr. Dobson's assertions. He was not asked any questions on cross-examination that would somehow imply that his statements are not true. Ms. Johnson went to great lengths to explain why she thinks Mr. Dobson is not a safe environment for the children. The court does agree with Ms. Brazel that the statements appear to be somewhat self-serving and they were untimely and they are vague in nature and unsupported by adequate evidentiary foundations for the court to consider them in some way that it's not a safe environment. With respect to Ms. Johnson's living environment and where the children are living, it appears as though they were sleeping on an air mattress. There's no indication in the record about the quality of Ms. Johnson's home, the safety of Ms. Johnson's home, which neighborhood she's in, crime in that area, drugs in that area, its adequacy and sufficiency. I don't have enough information on the record to make an adequate, appropriate factual finding with respect to whether Ms. Johnson could provide a safe environment for the children. That frankly wasn't mentioned or discussed in her declaration, which was untimely, and her testimony on it was rather circumspect. So I can't find the same. I find that this factor weighs in favor of Mr. Dobson. C, the children's developmental needs and the ability of each parent to meet those needs, both in the present and in the future. Mr. Dobson's declaration, again, which was unchallenged and uncontroverted, asserted that he provided nurturing behavior and adequate developmental assistance to the children, reading bedtime stories, showing them love and care and affection, doing things like getting them to school, providing an opportunity for the youngest child, FJ, to get into Head Start, had arranged to have the oldest child attend school. All of those indicate his ability, both present and in the future, to provide for the children's developmental needs. In terms of Ms. Johnson's declaration, again, I did not receive much information or evidence with respect to children's developmental needs other than her assertion that the children are doing well in school. Again, that assertion relies almost entirely on hearsay and educational records outside of the court's evidentiary record, and I can't make that finding. I find that this factor weighs in favor of Mr. Dobson. D, the sufficiency and stability of each parent's home environment. the impact of extended family, the length of time the child has lived in each parent's home, and the desirability of maintaining continuity in the child's home and community. In terms of the sufficiency of the parent's home environment, again, the court received an uncontested declaration from Mr. Dobson concerning his home environment. The court finds that that uncontested declaration indicates that Mr. Dobson has a sufficient and stable home environment. He has his mother and extended family that are very involved with the children when allowed to do so. The court finds that that is in the children's best interest. In terms of the length of time the child has lived in each parent's home, the court received evidence that the children lived in Valley City the entirety of their lives up until August of 2025. That at that time, the children were unilaterally removed from Valley City and placed in Bismarck. And then there was a transition from Bismarck to Mandan shortly thereafter. And the children have been in Mandan for approximately the last 9 months. It is desirable to maintain continuity in the children's home and community. The court finds the actions, the unilateral actions of Ms. Johnson in August of 2025 to have uprooted and frustrated that continuity in the children's home environment and community environment. Again, Mr. Dobson's declaration was uncontested. It asserted that the children were removed not only from the home environment, but from their school and community without even having an opportunity to say goodbye to their friends and to family in the area. The court finds that that weighs against Ms. Johnson and in Mr. Dobson's favor. E, the willingness and ability of each parent to facilitate and encourage a close and continuing relationship between the other parent and the child. Here from Mr. Dobson's request for interim order and the terms that he's requested in the interim order, the court finds that Mr. Dobson is willing and able and is going to continue to facilitate and encourage a close relationship and a continuing relationship between NJ and FJ and Ms. Johnson. The inverse, however, is not true. Ms. Johnson has unilaterally removed the children from Mr. Dobson's care and has unilaterally cut off all contact, whether that be in person, electronic, remote, telephonic contact between Mr. Dobson and the children. It appears that she is unwilling and unable to facilitate and encourage a close and continuing relationship with Mr. Dobson. And she has demonstrated that by alienating and withholding the children from Mr. Dobson, even after acknowledging that doing so is not in the children's best interest. The length of time it's taken her to get to this point demonstrates that she is willing to continue to alienate Mr. Dobson from the children, which the court finds not to be in the children's best interests. F, the moral fitness of the parents as that fitness impacts the child. Here, there were allegations made by Mr. Dobson that Ms. Johnson's willingness to alienate the children from him indicates a lack of morality and moral fitness as it impacts the child. Moral fitness is difficult to describe and make factual findings on in these types of cases. The court finds that that was insufficient and adequately addressed in other factors. In terms of Ms. Johnson's allegations against Mr. Dobson here, she suggests that Mr. Dobson is violent and abusive. By implication, I think the argument that Ms. Johnson was attempting to make was that he is a morally unfit person, although it was not made explicit and it was not developed adequately with a factual basis. I find that both parents appear to at least have moral fitness as it impacts the child, so I find this factor is neutral. The mental and physical health of the parents as the health impacts the children is factor G. The court again has the uncontested declaration of Mr. Dobson indicating that he is both mentally and physically healthy and has no concerns. That was unchallenged and uncontroverted. With respect to Miss Johnson, there were allegations that were confirmed by her testimony that she suffers from some mental disease or defect, namely PTSD, anxiety, and depression, and that she is not currently seeing a therapist. She is not currently under medication. The court finds that those mental health conditions can impact the health and well-being of the children, and Ms. Johnson is not taking adequate steps to control and treat those mental conditions, which pose the court some concern. I find this factor weighs slightly in favor of Mr. Dobson and against Ms. Johnson. H, the home, school, and community records of the child and the potential effect of any such change. Again, for the children's entire lifetimes, or at least the first 9 years of NJ and the first 4 years of FJ, the home, school, and community records of the children were that of being raised in Valley City, attending school, and being signed up for preschool in Valley City. In August of 2025, there was a drastic and material change caused by Ms. Johnson removing the children from Valley City, moving them to Bismarck, and then moving them again a month later. I'm assuming, and it was implied by the testimony, but it was not made express, that when the children moved to Bismarck, they would have been placed in the Bismarck school system, and they would have had to change schools between Bismarck School District and Mandan School District at some point in September, so a mid-school year change in school district. Mr. Dobson, in his request, has indicated an agreement and a desirability to maintain the children's current school placement through the end of the school year, but then to switch and give him essentially primary residential responsibility. So Mr. Dobson appears to understand the impact of a potential change in parenting or in primary residential responsibility and how that might affect the children and their homeschool and community records. Ms. Johnson did not consider those changes and the effects of those changes on the children when she removed them from Valley City in August of 2025. The court finds this factor based on the intention of the court here to follow, at least initially and in part, Mr. Dobson's request to keep the children in Mandan's school district through the end of the 2026 school year. And I should say the end of the 2025 to 2026 school year, and then transition the children over the summer. The court finds that that plan minimizes the potential effect of any change in the children's homeschool and community records. So I find that that factor weighs in favor of Mr. Dobson's plan and against Ms. Johnson's plan. I deals with children of sufficient maturity to make sound judgments expressing preference. Here, the court does not find either child, either NJ or FJ, to be of sufficient age and maturity to express a preference. Here, the court heard from Mr. Dobson, or at least in the declaration, assert that there was a preference expressed by the children. Ms. Johnson indicated that that preference was changed. Ultimately, I did not hear from the children, and I find a child at age 10 and a child at age 4 or 5 lacks the sufficient age and maturity to express a preference for primary residential responsibility, and so I don't find this factor applies. In terms of evidence of domestic violence, Factor J states, evidence of domestic violence in determining a parenting rights and responsibilities, the court shall consider evidence of domestic violence if the court finds credible evidence that domestic violence has occurred and there exists one incident of domestic violence which resulted in serious bodily injury or involved the use of a dangerous weapon, or there exists a pattern of domestic violence within a reasonable time proximate to the proceeding. This combination creates a rebuttable presumption that a parent who has perpetrated domestic violence may not be awarded residential responsibility for the child. Here, the court does not find domestic violence has occurred based on the definition of the statute. Domestic violence is defined under North Dakota Century Code section 1407.101. It's also set forth in 1407.7, that chapter as well. There's a cross-reference concerning the definition of domestic violence. Here, the court does not find and did not hear evidence of at least one incident that resulted in serious bodily injury. There were vague allegations about threats in which dangerous weapons were used. The court does not find that those have been proven with sufficient evidence to establish the presumption against Mr. Dobson having residential responsibility. In terms of a pattern of domestic violence, here the court did not hear much evidence concerning a pattern and certainly did not hear any evidence concerning the reasonable times proximate to the proceedings. The last incident would have allegedly occurred in 2023. And there were statements made about incidents involving domestic violence occurring between 2022 and 2023. Those are not within a reasonable time proximate to the proceeding. And so the court does not find Factor J applies. In terms of the interaction or interrelationship or potential for interaction or interrelationship with the child, with any person who resides in, presence or is present or frequents the household of a parent who may significantly affect the child's best interests. Mr. Dobson's declaration indicates that he has a support network of family and friends that are able to have a positive influence on the children's lives. Again, that was not controverted or contested. The court finds that to be accurate. In terms of other interactions, interrelationships, or the potential for interaction or interrelationship of the child with any other person, turning to Ms. Johnson, the court heard testimony that Ms. Johnson's father was abusive to Ms. Johnson when she was a child. She was placed in foster care, in part as a result of her father's abuse. That is concerning to the court. Ms. Johnson testified that she does not allow the children to be alone with her father, which raises red flags to the court as well. The court did not hear much in terms of others who interact with or have an interrelationship with the children. From Ms. Johnson's side, the court finds that this weighs in favor of Mr. Dobson. L, the making of false allegations not made in good faith by one parent against the other of harm to a child. Here, there has not been false allegations made with respect to harm to one of the children, and so the court does not find this factor applicable. The court does not consider any other factors to be relevant under Factor M. which is the last of the best interest factors. Having weighed and considered those best interest factors, the court generally is going to adopt Ms. Brazel's proposed interim order or proposed interim terms, Record Index 22. So the court adopts and incorporates as its interim order, paragraph 1, paragraph 2, paragraph 3, particularly important. Well, at issue here, I am ordering Ms. Johnson to disclose and immediately inform Mr. Dobson of the residential telephone numbers or cell numbers and address and any changes to the same so he can be informed. I understand that you have tried to keep those secret and withhold them from Mr. Dobson, but I want to make clear paragraph 3E is something I am ordering you to disclose. Paragraph G, I'm ordering both parties to follow. In fact, I adopt and incorporate paragraph 3, including all its subparts in its entirety. Paragraph 4 is standard language. The court adopts paragraph 4, including all of its subparts. In terms of paragraph 5, the court adopts and incorporates that as well. I'm going to skip paragraph 6 for a moment. I'm going to come back to it later. In terms of primary residential responsibility, Mr. Dobson shall have primary residential responsibility of the children, subject to Ms. Johnson's reasonable parenting time. This parenting time is going to change effective May 21, 2026. So from now until May 21, 2026, Ms. Johnson will exercise extended parenting time with the children so that NJ can complete her current school year in Mandan. So I incorporate paragraph 7. I incorporate paragraph 8A first sentence. I don't incorporate the second sentence starting with Michaela and ending with 6 p.m. Give me just a moment here. Take that back. I'll incorporate paragraph 8A in its entirety. (8B). The court adopts the first clause. The regular parenting time schedule will commence Friday, May 22, 2026 at 6 p.m. Well, I'll adopt all of paragraph 8B. I am going to require motivated transportation, which means that each parent will be responsible for transporting the children when it's time to exercise their parenting time. I understand Mr. Dobson has a driver's license and the ability to transport the children safely. I understand Ms. Johnson does not have a vehicle and does not currently possess a driver's license. Nevertheless, I'm ordering both parents to be responsible for transportation costs and transportation responsibilities. Both parents, when it is their turn to transport the children, are required to appear on time. The parent relinquishing parenting time is required to have the children present at a mutually acceptable exchange location at the time of the exchange. If the parties cannot agree on a mutual exchange location, the exchange location will be the parking lot of the Morton County Courthouse in Mandan, when the children are picked up in Mandan by Mr. Dobson. If the parties cannot agree on a mutual exchange location in Valley City, the exchange location will be the north parking lot of the Barnes County Courthouse in Valley City, North Dakota. When the children are being transported, they must be transported safely and legally, which requires that the children are transported wearing seatbelts in proper and age-appropriate and not expired child restraint systems appropriate for the children's age and weight. Those child restraints will be as recommended by the National Highway Traffic Safety Administration and must be placed in the vehicle in which the children are being transported in the recommended location, which means that if the child is to be seated facing the rear in the back seat, according to NHTSA, that's what the parties are required to do, with the children's restraint systems being appropriately and adequately maintained and installed, and the children must be restrained as required. The court adopts B1 as well. In the interim, I will tell the parties that once school commences, that might change. But in light of the significant period of time that Ms. Johnson withheld the children from Mr. Dobson, I consider this extended parenting time over the summer to be one of makeup time. Paragraph 9 is adopted. Nine A is adopted. 9B is adopted. The court's already addressed 10A. 10B I've modified. Ms. Brazel, did you catch the court's modification concerning exchange locations?
Yes, Your Honor.
All right, thank you. Ten C, the court adopts. 10D, the court adopts. Ten E, the first sentence the court adopts because I think it goes without saying that either party can request or call law enforcement if they have concerns about a parenting exchange or about conduct that occurred at a parenting exchange. I'm not going to order law enforcement to assist every exchange. So I don't agree with, and I won't incorporate E, second sentence. Circling back to Decision-making, paragraph 6. The court awards interim joint decision-making authority for NJ and FJ for all major decisions affecting NJ and or FJ, with both parties having the power and duty to protect, raise, educate, and discipline the children. With respect to particular decision-making authority under particular circumstances, the term decision-making responsibility means as follows. A, emergency medical decisions. Both parties are authorized to make emergency healthcare decisions for NJ and or FJ while NJ and or FJ are in their care, subject to the requirement that a party making an emergency medical decision must inform the other parent of the nature of the emergency and of the medical decision made or decisions made as soon as possible thereafter, but in no event less than 6 hours after making such decision. And it should be more than 6 hours. So bottom line, if there's an emergency and you need to make an emergency medical decision, each party is entitled to do so, but they are required to, within 6 hours of that decision, inform the other party of the emergency and the decision made. For major and or elective medical decisions, Mr. Dobson will have the ability to make any elective or non-emergent but non-routine medical procedure decision in the interim. Day-to-day decisions, each party is authorized to make day-to-day decisions regarding the day-to-day care and control of the children while the children are in that parent's care. Education and daycare placement. Right now, the children, or at least NJ, is enrolled in school in the Mandan School District. Neither party has the authority to modify that school educational placement this school year without the expressed written consent of the other party or court order. After the end of the school year, Mr. Dobson has the authority to modify NJ and FJ's educational placement over the summer and going into the fall of 2026. Each party may utilize appropriate daycare or after-school programs or preschool programs for NJ and or FJ at their sole expense for periods less than 12 hours. Non-emergency healthcare decisions, all routine non-emergency health conditions for NJ and FJ, for example, vaccines, routine regular checkups, physicals, etc. Those decisions shall be made by Mr. Dobson. Religion and spirituality, neither party shall modify the children's religious or spiritual upbringing in the interim without express written consent of the other party or court order. Residence, each party shall inform the other of their residence address, their residence phone number, cell phone number, if they don't have a residence phone number, and the name and relationship of any person with whom they reside. And the parties have an obligation to inform each other of any changes within 24 hours to any of that information. In terms of first refusal, if either parent is going to be absent or away from NJ and or FJ for more than 1 day or longer during their respective parenting time, or the entirety of their parenting time, or if they are otherwise unavailable to care for the children during their parenting time, the parent shall offer the other parent the time that they would be gone from the children before offering it to a third party. If the parties utilize daycare or after-school or preschool programs for more than 12 consecutive hours in a 24-hour period, that parent must first offer the other parent parenting time with the children. I understand that due to the distance that will become very difficult, but nevertheless, it gives that parent an opportunity to exercise parenting time in the event of an extended absence from the children from either party. The parties must ensure that the children are safe at all times, complying with all caretaking laws, common sense, community standards of care, and the like. Neither parent may permit the presence or use of any illegal or illicit controlled substances or drugs around either NJ or FJ at any time. This includes marijuana. This includes any and all substances that are controlled under the Controlled Substances Act. Neither parent shall consume or use any illicit substance, including marijuana or alcohol, within the previous 48 hours of exercising their parenting time with the children. Neither party shall drink alcohol or be intoxicated in the presence of the children. Neither party shall expose the children to secondhand smoke, whether that be tobacco, marijuana, or otherwise, in their homes, vehicles, or elsewhere, and shall attempt to shield the children from secondhand smoke in the community. The party shall not expose the children to inappropriate media, for example, movies, CDs, DVDs, Blu-rays, music, video games, websites, internet applications, etc., beyond the children's respective age and maturity limits. The parties must abide by the rating suggestions to the greatest extent possible. Neither party can allow either child to be in the presence of any person convicted of a crime of a sexual nature or who is or has been required to register as either a sexual offender or offender against children. No such person is allowed to be in the party's dwelling or in a structure in which the child or children are staying or sleeping. Paragraph 11, the parties are required to communicate in a positive and respectful ways, cannot make derogatory remarks, limit their communications to discussing matters involving the children. Paragraph 11 is adopted, including its subparts in its entirety. Neither party may take either child outside the state of North Dakota or allow another party to take the child or children outside the state of North Dakota for longer than 12 hours without the advanced permission or written consent of the other party or an order from the court. In terms of any communication, neither party may restrict or prohibit the parent not exercising parenting time from communicating with either NJ or FJ. Both parties must make available to the children frequent liberal visitation by reliable electronic means, including Zoom, FaceTime, Skype, or telephone, with the off-duty parent or parent not exercising parenting time. The on-duty parent exercising parenting time shall not unreasonably deny the other parent's reasonable requests for electronic communication with the children by reliable electronic means, considering the children's schedules, routines, and activities. In terms of a holiday schedule, we do have some holidays coming up. All right. So my schedule, at least in the interim, will apply to the year 2026 and the year 2027. The second half of winter break, starting at 6 o'clock on the day marking the midpoint of the winter break from school until the day before school resumes. For 2026, that's not applicable because it's already expired. In 2027. That second half will, if we still have an interim order at that point, that parenting time will be Ms. Johnson's. Easter weekend of 2026 is not applicable because it's already expired in 2026. In 2027, Easter will be Mr. Dobson. and that goes from the day school lets out for the break through 6 p.m. on the day before school resumes. Mother's Day, 6 p.m. through 9 p.m. will always be Ms. Johnson. Memorial Weekend from Friday at 6 to Monday at 6 in 2026 will be Mr. Dobson. In 2027, it'll be Ms. Johnson. Father's Day from 6 p.m. until 9 p.m. will always be Mr. Dobson. Independence Day from July 3, 6 p.m. through July 5 at 6 p.m. will be Ms. Johnson this year and Mr. Dobson in 2027. Labor Day will be Mr. Johnson this year. Sorry, Mr. Dobson, Ms. Johnson in 2027. The fall conference for the North Dakota Conference of Educational Leaders, that school break, will be Mr. Dobson in 2026, Ms. Johnson in 2027. First half of Thanksgiving from when school lets out on Wednesday through 6 p.m. on Friday will be Ms. Johnson in 2026 and Mr. Dobson in 2027. Second half of Thanksgiving break from 6 o'clock Friday through 6 the day before school resumes will be the inverse of the previous order. And the first half of winter break will be Mr. Dobson when school lets out 6 p.m. until the day marking the midpoint of the winter break in 2027. That will be Ms. Johnson. I don't think that this case will be continued that long. I'm hoping the parties can work out an appropriate time. But nevertheless, if it is still going on in 2027, I went through the end of this year and all of next year as well. For that holiday schedule will take preference and precedence and supersede regular parenting time. I don't have in that holiday schedule the children's birthdays or the parents' birthdays. Those just happen to fall as they fall in the regular parenting time schedule. Modifications. Paragraph 12, 13 and 14 are adopted and incorporated. I find those to be reasonable. At this time, the court does not award child support. At this time, Mr. Dobson has indicated that he has the ability to put the children on insurance. I'm assuming that it right now is not the open enrollment period. So I'll reserve the insurance decision for now. Any insurance coverage for the children at this time shall remain in effect and in the same form and amount in the interim period. No changes to the children's insurance policies are allowed in the interim without order of the court. And any parties paying premiums must continue to pay those premiums as applicable until further order of the court. Uncovered costs shall be equally divided between the parties 50-50. If one parent has incurred those non-covered healthcare expenses for either NJ or FJ, the parent must provide proof of the expense to the other parent within 60 days a claim for reimbursement not made within those 60 days of insurance processing is deemed waived and forfeit. Once a parent receives proof of a non-covered health expense, that parent shall reimburse the other paying parent within 60 days. If either parent fails to reimburse the other paying parent within that time frame, the non-paying parent should be responsible for all legal fees incurred by the paying parent in their efforts collecting reimbursement. Under that paragraph, all other requests for interim relief are denied and or reserved for trial. Ms. Brazel, did I get everything that you had requested?
Yes, Your Honor.
Do you have any questions about what I ordered?
No, Your Honor.
All right, and I don't care if you incorporate the attorney's fees finding into that interim order as well, or if you want to do that in a separate order, as long as that order on objections and attorney's fees makes it into a proposed written order as well, so I can sign it and it's made part of the record. However you want to fashion and format that, please serve your proposed interim order and proposed order on the objections and fees on Mr. Copy and Mr. Byers. And Mr. Byers, if ordinarily I'd give you 14 days to respond to make sure that it's consistent with what I ordered before I would sign those documents. That's what the rule requires. But in light of the interim nature and the emergent nature of the order, if you could review it as soon as possible and tell me whether you accept or have any corrections or objections, I would appreciate it so I can get that written order signed as soon as possible and the parties have a document that they can refer to. Any questions about that, Mr. Byers?
No, Your Honor.
All right. Anything else from either party?
No, Your Honor.
No, Your Honor.
Hearing nothing, we are adjourned. Have a good day.